Kevin Flynn.
Rebecca Lavoie, is this the Readathon?
We are in a new Readathon.
Oh, Happy New Year.
Our first Readathon of 2025, and it is jam-packed with news stuff. We were last on the mic about a month ago, but things seem to be heating up, so I would not be surprised if our readathons become a little more frequent now that is the new year. So, are you ready to start with some items that we can get through before we get to the big focus of this episode?
Yeah, sure.
All right. Item 1. Do you remember who Ken Berkowitz is?
Is he the chief or the former police chief of Canton? And even though that his department was recused from the investigation of John O'Keefe's death, he somehow he was said that he was driving by the house and found the piece of plastic taillight that
Correct.
no one had found before.
While the CERT team did not report finding these pieces of taillight, yes, Ken Berkowitz happened to be driving by the Alberts house on 34 Fairview, saw some taillight pieces just lying there, and those pieces have become key evidence in the trial.
Okay.
Ken Berkowitz, by the way, sort of mysteriously resigned in 2022. I say mysteriously because people of Canton were never given an explanation as to his resignation, and it was a kind of a big story there. But yeah, there are big questions as to his involvement in this case, and there is allegedly some lost video of his retirement party at which he's real buddy-buddy with the Alberts. So, Kevin, Ken Berkowitz died.
Oh, okay.
Yeah, so that's why we're talking about him,
All
because
right.
he passed away, and I don't know if that was the reason for his retirement, that he was ill.
Might have been ill, yeah.
But I also think that he was in poor health for a long time. I remember reading about that. So he's definitely not going to be testifying at the next trial, for sure.
Yeah, so that might be a bit of a complication if the defense wants to proffer the theory that that evidence was placed there.
Right.
Because they won't have someone to question. But all right.
They also, by the way, do have the lack of evidence being found before and then it being entered into evidence much later. So they do have that. Item number 2, Joshua Levy. Do you remember who he is?
I believe he is the U.S. attorney for Massachusetts.
Yes, the District of Massachusetts. As I predicted, U.S. Attorney Joshua Levy is out of a job after the election of incoming President Donald Trump. He announced
So are a lot of U.S. attorneys.
Yeah,
so
well,
not really.
Well, what happened
shock,
was
yeah.
he announced his resignation, and that's actually common. Presidential appointees, department heads, et cetera, they resign, and then a lot of them are rehired. And the resignation is largely symbolic, like you didn't pick me, I serve at the pleasure of the president. There's a new president, but it appears as though Levy is truly out. This is not a symbolic resignation. He's really out of this job.
Yeah.
He sat down with some members of the media last week and gave a little mini press conference that was a roundtable style press conference. And he was asked about the alleged investigation of his office into the Karen Read investigation. Do you want to hear what he had to say about that?
I'd love to hear what he has to say about it.
All right, this is from a local news story.
Though it's clear from testimony in the Karen Read trial that Levy's office has extensively investigated that case, he would not confirm that because no charges have been brought to date.
We never publicly discussed whether or not we're doing an investigation related to Karen Read, and I'm not going to take questions on that.
All right, Kevin, what did you hear there?
I heard the no comment. What
do you think that means?
Well, I mean, you take him at face value and say we don't comment on that, or we have never said that, but we all know that the FBI is the source for a lot of this stuff. So, I mean, it'd be nice if he sort of like dropped a bomb on the way out, but I think really what he wants to do is preserve that investigation.
Absolutely. What I didn't hear was him saying there was an investigation or there wasn't an investigation or we don't come. He spoke in such a way, leaving the door open that investigation is ongoing, which I thought was very interesting. All right, next item. Turtle Boy. Do you remember how he was in this legal dispute with this woman, Lindsay Gaetani? We talked about it on a previous episode.
Right. This is a woman that had briefly they'd been in a relationship, and she filed a restraining order against him, alleging
That she was afraid of him.
That she was afraid of him. And was there an allegation of physical violence or just a threat of it?
That was an allegation from her, but he was never charged with, there was an allegation of sexual violence. He was never charged with that. The police actually found no evidence of that. And they have been locked in this battle. She ended up getting a restraining order against him that ended up preventing him from being able to do his reporting on the Karen Read case. She would show up places so that he couldn't be there, sort of on purpose. And remember, and I just want to say this again, I do not condone the personal opinions of Turtle Boy, nor his political stances. However, his work in this case has been groundbreaking and exemplary, and this particular dispute with Lindsay Gaetani really points to more evidence of corruption in the Norfolk County DA's office. Do you remember why that is?
Well, I think there was some indication that she may have been working hand in hand with the government on certain aspects of the investigation into Turtle Boy and, by extension, the Karen Read case.
Yes. From the phone extraction taken from this case, they were able to find some text messages between her and this woman, Kate Peter, where they talked about colluding with Brian Tully, who they were in contact with, Adam Lally, who they were apparently in contact with, who Kate Peter was in contact with, and basically setting him up to get charged with witness intimidation and because they were going to say Lindsay Gaetani was a witness of some kind.
So that's what the text messages say in black and white, that they were in communication with all these state police troopers and that they were coordinating activities.
Yes. And Lindsay Gaetani had an open phone line to one of these parties. I believe it was Tully during her confrontation with Turtle Boy. So clearly she had was basically taping it, basically. So what ended up happening was they had a hearing that was actually at the same time as the other hearing we're going to be talking about, where she was arguing that her restraining order needed to be basically renewed. She lost that hearing, largely because you cannot make the case that you're afraid of somebody when you persistently and continuously attack them and defame them on social media in a violent way, and when you are actually threatening other people and their children on social media, something she is now being investigated for because there's now a restraining order against her from somebody she threatened on Twitter. So,
and these text messages, did they not show that her plan was to engage with him?
Yes.
So it's hard to,
the
stand by.
meeting itself was in order to basically entrap him. And so it's hard to stand by being afraid of him.
I'm afraid of him, but when you're working with the police to set up a meeting with him, that doesn't... one can be afraid and anxious about their interactions with another person, but it doesn't necessarily rise to the level of a criminal offense that the need for some kind of criminal injunctive relief to keep that person away from you. So you just can't get restraining orders against...
In Massachusetts, apparently, it's very easy. But there were some interesting things that are related to this that I just want to mention. One is that, they actually were able to obtain a full cell phone extraction from Lindsay Gaetani that is now under seal. So they had to return that to the court after they won this case.
The phone or the data?
The data.
Okay.
Okay. So they can't talk about it openly. He can't post tweets about it. He can't share it publicly. But clearly that cell phone extraction was important. Second, as soon as he won this hearing, he filed a lawsuit for $2 million for defamation against Lindsay Gaetani, pointing to her many, many, many social media posts that, by the way, his lawyer, Bradel, dropped in front of her in court at this hearing. This 3-inch stack of paper of her defaming him, attacking him, saying violent things about him and other people, just dropped it right in front of her in
Did
court.
it have all those little flags on it? So it'd be turn to the red flag?
Probably.
No, they didn't do all that. Okay.
It was about 250 pages apparently, and that was interesting. But then, after filing this lawsuit, he now has tweeted and giving this person a deadline of, as we tape this, 22 minutes ago. This woman, Jen Coffendander. Now, I don't know if I've talked about her before on the podcast.
There's a lot of Jens, but this one doesn't sound familiar,
Jen Coffendander has the letters FBI in her Twitter handle. It's like Jen Coffendander FBI, okay?
Okay, yeah.
She says that she used to work for the FBI. I have no reason to believe that she didn't, but that's what she says. She has a large social media presence. She takes very hard Nancy Grace-like stances on cases on social media.
Okay.
So, for instance, after the JonBenet Ramsey documentary, which basically shows that the FBI cleared the Ramseys in that case, she is out there vehemently tweeting about their guilt and all the things that point to their guilt.
Is she a local? As far as you can tell?
I don't think she's a local, but she has a large social media presence.
She's invested in this case, and
right.
so she's commenting. Okay.
And Aidan Carney was able to retrieve, either through his legal actions or through a source, internal emails of the Norfolk County DA's office where they plan to work with her and have her share, supposed evidence, etc., of Karen Read's guilt in the Karen Read case. So there's emails saying, this woman reached out to us. I think we should engage with her. She has a large social media following, okay? So not only has she been tweeting conspiracy theories, unfounded claims, full guilt claims about Karen Read, she's come after me a few times on Twitter, but she has also been one of these people who's making claims about Turtle Boy on Twitter. So here's what he tweeted to her after he filed this $2 million lawsuit against Lindsay Gaetani. Here's an excerpt of it. This is to Jennifer. And she blocked him, so he posted this online. As you may have seen, I filed a defamation suit in Worcester County Superior Court for $2 million yesterday because someone repeatedly made claims similar to yours. I am asking you to immediately do the following to correct the defamatory statements seen below. 1, remove the defamatory tweets. 2, issue a public statement on your YouTube and Twitter accounts admitting that you have no evidence whatsoever that I do drugs or am a drug addict. One of her claims about him. She said that, by the way, because he would... he blew his nose during a live stream that he was a drug addict.
Okay.
Issue a public statement on your YouTube and Twitter accounts admitting that I have never emailed you nor threatened you and your children, something else she also claimed. Issue a public statement on your Twitter and YouTube accounts admitting that I have never been accused by any law enforcement agencies of rape and that the Medfield police determined after looking at video evidence that he says no such statement ever occurred. I think he means no such crime ever occurred. So it is important to remember that he has this evidence of the Norfolk County DA's office basically working with this woman. It's important to note that he sent this out into the world and that she immediately shut down all comments on her social media, etc. And he gave her this deadline. I don't know. I don't believe that she made the deadline because I didn't see anything about it before we began to tape. But she's been a real thorn in the Free Karen Read side because she uses her FBI former employment to make claims that are just not fucking true.
Right.
And she also basically, by the way, shits on the FBI investigation into this case while she's doing her own former employer.
Yeah, right.
So anyway, that's something that I'm keeping an eye on.
Okay.
Another development. Do you know what the company Cellbrite is?
Okay, so this sounds like this was one of the companies that did the whole search around how long to die in snow and
other phones.
And other thing. Right, okay.
Cellbrite is software made by a company called Cellbrite, which I believe is a Massachusetts-based company. It's a software that cops use to do cell phone extractions because it basically brings the extraction, puts it in layman's terms, makes it easy for anyone to understand, even a dummy like Nicholas Guarino. I'm going to cite an article for you. In a decision that could have a major impact on the Karen Read case, the Massachusetts Supreme Judicial Court, that's the highest court in Massachusetts, tossed out a man's appeal of his conviction for possessing child sex abuse materials, finding a judge was correct to allow testimony on the use of a system to extract data from cell phones. So basically, this judge held up the use of Cellbrite. The man, Dave Cronin Jr., based his appeal on a claim that a judge improperly allowed testimony from police officer Michael McLaughlin on his examination of the phone. I'm going to paraphrase now. Basically, this cop had said, yeah, I'm not an expert, but this software makes it so it doesn't matter that I'm not an expert. Here's what the phone says. And basically, the appeal was, you need an expert on cell phones to make these claims about my phone, okay? So he lost that appeal. The Supreme Court says Cellbrite is good enough. So this affects the Karen Read case because there are contradicting witnesses around Cellbrite in the Karen Read case. All right. There is one who actually works at Cellbrite who has been the prosecution's witness, and his analysis has been interesting because his analysis, the defense expert on cell phone technology, Richard Green, claims that the original analysis that was used from the Cellbrite stuff, you basically use a different version of the iOS that they shouldn't have used. So basically what this means is Cellbrite is right And it actually could land either way. Cellbrite has since made updates to their software that they claim show that Jennifer McCabe did not make that search at 2-something a.m. But other experts in the field say, no, just because you're removing timestamps from searches on Cellbrite does not mean those searches didn't happen at those times. So there's a lot of conflict around what the software did and didn't do.
Right. But the case isn't an affirmation of the how good the software is. It's a rejection of a claim that someone's rights were violated because of the way it was used.
Correct. But the decision did imply that the software was good enough. Yeah, a non-expert could look at it and make claims.
Right. It'd be a big win if the court ruled that this was not good technology and you couldn't base hard evidence on it. Right. But it's like it's somewhat neutral in the other way, that it's just saying yes, you can you can use this.
Right. So as I mentioned, the defense expert on the cell phone stuff, Jennifer McCabe stuff, was named Richard Green. The prosecution has filed a motion to exclude him from the next trial, saying an expert they hired, Ian Whiffen, who works at Cellbrite, found no evidence to support Green's claims. They claim that Green's claims, his expert claims, will, quote, confuse the jury. So basically, they only want their side of the story in court. They do not want an opposing expert.
That would be great if the prosecution in all cases could just say, hey, let's just use our expert witness. Well, the defense doesn't need to have one.
Speaking of that, the prosecution has also filed a motion to exclude Daniel Wolf and Andrew Rentschler from testifying in trial number 2. Remember who those guys were?
Are those the ARCA guys?
Those are the ARCA crash daddies.
Crash daddy. Yeah.
Yeah. So these are the experts who came in, who were hired by the FBI to investigate this case. Of course, Josh Levy won't confirm that, but there are legal proceedings that have proven that. And they want to exclude them because, quote, the history and complexity of the ARCA witnesses' employment and directives are muddled and unnecessary to recount for the purpose of this notice. Rather, it is expected that if the defense attempts to proffer either or both witnesses, it will be unable to comply with Rule 14 obligations. The Commonwealth does not allege the defense will be negligent and unwilling to comply. It is expected that given the handling and employment of these witnesses, the defense will simply be unable to meet their obligations, basically to prove that they're good witnesses. So basically, they are saying, as proponents of the witnesses, it is incumbent upon the proponent to comply with these rules. And basically, what they're saying is, because they can't talk about who these guys worked for.
The FBI.
Right. Then they can't meet the obligation that they should be voir dired in as witnesses.
Right. And what feedback did we get from the jurors about the ARCA witnesses?
That the only thing that was consistent that would have changed their mind was knowing that it was the FBI who employed these guys.
Right.
Yeah.
Right, because they wondered perhaps this was an insurance company, whatever. But and they even said one of them said that, like, upon finding out after the trial that it was the FBI, it would have changed my mind about how important that evidence was and how to weigh it.
Yeah. Right. So basically,
the prosecution's like, well, let's not get stuck in that shit again.
Yeah, but what's interesting is they have the same judge, so they're asking the judge to reverse her own orders on Dr. Marie Russell, on the ARCA guys, on Richard Green, because the judge allowed them all in trial once. They're basically asking her to say, you were wrong, and no, they shouldn't be, and you're right. After seeing what happened the first time, you're right.
Well, you know what, like, my counter argument would be, like, my responding brief would be about that. You know, of all the points that I would make, like, if the state says that they can't be, they can't be qualified witnesses, or they're not suitable witnesses because they can't explain who hired them, then the prosecution in state should, like, be okay with letting them say who it was.
Exactly. That is a much better remedy, I think, than anything else.
Your Honor, like, if Your Honor should, like, consider, like, rectifying this by allowing them to say who hired them.
If you're listening to this, Beverly Cannoni, if you belong to our Patreon, we've just given you the better remedy for this situation. All right, small item, but interesting. Boston Magazine's Gretchen Voss. Do you remember who she is?
Okay, she wrote that long form piece about Karen Reed. She hung out with Karen for a couple of days, and I
think you're confusing her with the Vanity Fair piece.
Oh, okay.
But she did write a long form piece about Karen Reed earlier in the case, and Judge Beverly Cannoni ordered that her reporter's notes unedited interview tape, etc., should be turned over to the prosecution because Massachusetts does not have a reporter shield law. So she is now fighting that order on turning over those materials. There will be a hearing on it on January 31st. Non-party Gretchen Voss is to provide off-the-record notes to the court for in-camera review by January 13th. Do you want to explain what in-camera review is?
Well, that means that the judge would take it into her own chambers, not in public, and then review it and then make a decision whether or not this is something that ought to be part of the public record and be or the trial record or whatever, to make it public. So it's basically taking a look ahead of time. That way, like, they can make a determination as opposed to putting something that might be prejudicial or maybe irrelevant or otherwise would be cause irreparable harm. That, like, she can make a determination of it. Interesting enough that this was something that happened, as you know, in the defamation case around the podcast The 13th Step.
Yes, the defamation case against my station and employees of my station.
Where the judge took the information.
Judge Dan St. Hilaire took all the, there was extractions done on my colleagues' devices, Slack messages, emails, DMs, text messages, etc. And he took that, all of the notes, all of the unedited stuff. He did an in-camera review and determined that not only did NHPR meet the standard of not doing actual malice and defamation, but that NHPR actually went further than they needed to go in vetting this story.
Yeah, now this is what makes this different. This is not a libel case here. They're basically just like looking for the information.
Right.
And, in a way, I think that she probably will allow, what she's going to look at is probably, not going to be very different than what's been published.
Yeah.
Just, kind of longer. I don't think there's like a smoking gun that's going to sit there, because it's kind of silly to think that the reporter would go through all this trouble and get, a piece of information that's really big and sit on it. I think more likely, they're trying to like pick up as many inconsistencies as they can. But I think, I just like don't read too much into the fact that the reporter is fighting it. Largely fighting it, I think, on professional grounds. They're not fighting it because they've got something to hide.
No, they're fighting it because they don't want to set the precedent.
They don't want to set the precedent.
Stuff.
Yeah. So that's, I think, and that's going to be the argument. And, we'll see if that wins. But I don't think that this like is really going to make or break any case.
No, I don't think so either. All right, you ready to get to the main event?
Yeah. By the way, do you think like the Commonwealth will try to subpoena like the raw file of our readathon?
You're welcome to it, guys. You're idiots.
Yeah.
So speaking of that, the main event, you might remember that before the holidays, Dr. Marie Russell, the defense's dog bite expert who testified in the first trial, was challenged by the prosecution, and there was a hearing basically to revoir dire Dr. Marie Russell. A hearing that we all expected would take a couple of hours. The first part of the hearing took an entire day. And then the prosecution said it had so many questions that they would need at least one more day. So Judge Beverly Cannoni rescheduled it for January, and so that hearing happened. I will just say a couple of things up at the start. I think my hopes that Hank Brennan would, in fact, deliver the dignified prosecution that he promised, and as well as other people's hopes, have been completely dashed.
Oh, no.
He is a prick. He's whiny. He's condescending.
This is the guy that the district attorney hired.
Correct. He's a special prosecutor.
An outside attorney to be the special prosecutor. Okay.
And I think it's worth noting, too, that Dr. Marie Russell has been brought in. She's had more time to look at stuff, and she says she's now even more certain about the dog bites than she was before.
And just so I'm clear that the focus of the hearing, is it based on her qualifications to be a witness, or is it about the evidence?
It's technically that. It's technically her qualifications, and then it turned
which
into
is like for the ARCA guys, like that's the like if those are the arguments you would expect that the state would make.
Right.
Is that like they can't testify because they are not qualified.
Right.
Not they can't testify because they're going to say something that's going to hurt us.
Right. So if only it were that, the hearing would have been over after she stated her qualifications.
Yeah, right, yeah.
This turned into essentially a repeat of trial one. Hank Brennan repeatedly stated Commonwealth claims as facts during his questioning of Dr. Russell. So, for instance, there were dozens and dozens of questions like this, and I pulled some of this from different reporting, and I also watched the hearing, but I ended up looking at some different reporting. So, one of the questions asked was, do you know how fast the Lexus was traveling backwards when it hit Mr. O'Keefe?
The dog bite expert?
That was a question.
Okay. What was the answer? It probably was like, no.
Yeah. What position was his body in at the time the car allegedly collided with him? So remember, it's never been proven that O'Keefe was hit by a car, right?
Yeah.
And they were asking these questions as if it was fact that he had been hit by a car, all right? They asked if she had reviewed opinions that this other doctor, Dr. Kenneth Kinsey, said that John's injuries didn't come from a dog. Dr. Russell said she has no idea who he is. And by the way, Dr. Kinsey, as it turns out, testified about ballistics at the Murdoch trial. He's frequently on TV as like a commentator. So
he was a ballistics expert.
Yes.
Who now is
I think he's a pattern expert.
A pattern expert. Oh, okay.
Right. And apparently Brennan did not get this information directly from Dr. Kenneth Kinsey, but from one of his media appearances on a YouTube podcast called The 13th Juror. Okay.
Okay.
But what Brennan did not mention, and Turtle Boy said this, and I went and looked it up, and it is true. Dr. Kinsey specifically said that he doesn't believe O'Keefe's injuries came from being hit by a car either.
Oops.
Right.
Okay. All right.
All right. A very fun exchange related to the previous news. One of the questions we were asked was, would it help you to know that she told Boston Magazine that maybe John hit the back of her car and she ran over his foot? Would that help you? Would that help you differential diagnosis? She said it wouldn't help because those wounds were caused by a dog.
Yeah.
He purposely interchanged plastic with tempered glass. There was a very long series of questions about the wounds that tempered glass make, or that glass makes. And she said, I'm very familiar with glass wounds. I saw them all the time in the emergency room.
Yep.
And she was able to say regular glass and tempered glass are different. And tempered glass makes a very specific pattern that was not here.
Tempered glass, not safety glass, which is glass like windshield glass.
They meant windshield glass.
They did? Okay.
Yes.
Which spider webs?
I think tempered is a like blanket term for glass that doesn't shatter. Okay.
Right, yeah.
So I was thinking, wow, are they going to claim that he was hit by the windshield or the glass? I don't know. But no, he then started saying, would you feel differently if you knew that pieces of glass from her taillight were found embedded in John O'Keefe's clothing? He got called to a sidebar because the defense complained that was not glass. It was plastic. And he knew that. And he was purposely asking the doctor a question that was not based in fact, which was that her taillight was made from glass and these cuts could be caused by glass. All right. It is very important to note that there is no direct evidence that glass was found on John O'Keefe's sweater because the chain of custody was terrible. And Dr. Marie Russell said that on the stand. There were problems collecting this evidence. So no, it wouldn't change her mind. Okay. And I should say that Russell did have some snappy answers. She did, for instance, say when he was asking if she had more experience than other people, she said, I have at least as much experience as any other possible choice that you have. Okay.
Good answer.
Yeah, that was really, really interesting. He said it was outrageous that Dr. Russell didn't know the debris field distribution at the crime scene. Guess who knows the debris field distribution at the crime scene?
I don't know who.
Nobody.
Oh, nobody?
Because nobody even knows where their body was. And nobody has pictures from that night of a debris field distribution.
Really? I thought they used like a snowblower to discover all that information.
Yes. No, they didn't use a snowblower. They used a leaf blower.
Leaf blower, that's it. Yeah, snowblower would be a little more.
All right. Are you ready for some truly nutty moments? Nutty moment number 1. Brennan was discussing the abrasions and marks on John O'Keefe's arm. This picture was up on there the whole time. And said, did you know that John O'Keefe was Irish?
Did I know?
Guess why he would ask that question?
No idea. Because of his rosy skin?
He was claiming that some of those abrasions were freckles.
Some of the abrasions, the abrasion, not the puncture wounds.
The scratches. They're all called abrasions.
Okay,
Every wound is called an abrasion.
Okay.
He was claiming that some of what we saw in the picture was actually freckles. Dr. Marie Russell fired back, oh, so you're a doctor?
Ah.
Yeah. So there's 2 things that happened that were truly nuts. Get ready for this.
Yeah.
In a series of questions about bite mark pattern evidence, which as we know is junk science, and Dr. Marie Russell knows that as well. Hank Brennan claimed that the Commonwealth actually did find Chloe before her previous voir dire and took bite impressions of Chloe's mouth.
Wait, they say there are bite impressions of the dog.
They say that Yuri Buchanan saw Chloe in person and took bite imprints of the dog.
Where are those bite imprints?
Exactly. There is zero evidence that the dog they claim to have taken molds from actually is Chloe. If there are molds, those molds were never entered into evidence.
That is crazy.
The defense was not allowed to attend this alleged procedure. And it could be a potential Brady violation.
I'm just saying. That seems like a huge disclosure problem.
The defense was never told where the dog was. Remember that? So that they could see Chloe themselves. Apparently, the Commonwealth claims that they knew where the dog was almost the whole time, like during the last trial.
Yeah.
But
yeah.
It's important also to note, they also say that Chloe was rehomed again.
Yeah.
I mean, which means if that's true, it means she probably bit someone in the new house, right?
Yeah. But these bite molds are both useless and useful because it's useful because it seems to be like grounds for a sanction, a mistrial, something like that, because it wasn't disclosed. The reason it's useless is they have no way to confirm these are Chloe's.
Correct.
Because they could have gotten another dog, do a bite mold, a bite mold, and to the extent that we already know that the bite marks kind of junk shit science.
Right.
If it's somebody else's dog, well, obviously it's not going to line up.
Yes,
there's
also,
no way to confirm that. Yeah.
This was 2021 that this happened.
Yeah.
And I've looked it up, and people online have claimed it, and I looked it up. Dog bites change significantly over time as dogs age because their teeth move so much. We know this from our own dogs.
Yeah,
They get underbites. Their dogs are fucked up.
Yeah.
So they'd be useless anyway if they were taken 2 years after the crime or whatever, right?
Yeah.
Also, remember that the Commonwealth, they never took DNA samples from John's arm to look for DNA. They only allegedly tested his sweater. They found the pig DNA or whatever. And of course, no one ever talks about the fact that there was vomit all over John, all over his clothes and his underwear, et cetera. But anyway, I'm not saying that's the dog's. I'm saying that was his. But yeah, so they're probably not admissible. And the evidence of this existing is a potential Brady violation if it in fact exists. Do you know what I think?
What?
I don't think this is about Dr. Russell. I think Hank Brennan is trying to taint a potential jury pool for this case by putting, just like Morrissey did, putting information into the public sphere that is not true or baseless or doesn't have anything to do with the trial in order to sway public opinion.
It's funny you say that because when you come back to Jennifer from the FBI, that it seems to me like the only value that she has, if she doesn't have any firsthand information and she doesn't have any expert testimony or expertise that can't be divined from some other witness, that the only value seems to be her social media following because they flag that. And so it sounds to me like they want to employ that in extrajudicial. They want to get, again, taint the jury pool and put. Yeah, I mean there are bar standards about publicity and things that you can say in trials and outside of the courtroom. In some states, they're looser than others. This seems to be the tactic here.
Yes.
Is the only reason. Yes.
And these are lawyers.
So they don't need a bunch of nosy podcasters coming around and giving their hot takes about their fuck-ups.
Right.
Okay.
So at the end of this hearing, there were closing...
I'm fired up.
I know.
I'm fired up, Rebecca.
You're about to get more fired.
Oh, okay. All right.
At the end of this hearing, there were closing statements. Hank Brennan's closing statement was a reassertion of all of these false and or unprovable claims about the facts of the Karen Reed case that were not facts.
Yeah, now that's something we talked about a lot, is that the prosecution said X, but
and didn't prove it.
And never introduced evidence to back that up.
Exactly.
And it seemed to me, I was like, why hasn't the defense questioned that? Why have they not objected to the, saying what if you knew there was microscopic this on the that?
Funny you should say that, Kevin.
Okay, all right.
You know who also got to make a closing statement? Was Karen's new pro bono, totally badass attorney, Robert Alessi. for about 20 minutes. And I would say that anyone listening to this should, the Young Jerks, which is a podcast on YouTube, has like, they post all these videos and they have videos of the whole hearing. Go all the way to the end. It's many, many, many hours to the last 20 minutes or so. And you will see the most blistering, completely decimating closing statement I have ever heard in court, period. He basically called the prosecution on all their bullshit. I'm going to play a very small sample of that for you. This is thanks to Olivia Lambeau, who posted this sample on her Twitter, because this was also my favorite moment of his closing.
The greatest danger to a defense right to a jury trial and present its witnesses is to have an entire motion supported by nothing but the assertions of an attorney on the other side.
Yep.
That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist.
Can we get an amen?
Amen.
I mean, that's what we've been saying for months and months and months.
We smart.
That just because you say, would it change your mind to know that they found X, Y, or Z? Would it change your mind to know that Karen Read said, I hit him, I hit him, I hit him? Which, by the way, there is no proof that she said. None. There are witnesses who said she said it, but there's absolutely nothing in the contemporaneous reports that say that she said that. It all happened way after. And also, just to remind people about the I did it, and just to remind people about Jennifer McCabe claiming that she said that, and Jennifer McCabe claiming that Karen Read asked her to make that search for her phone. One of the claims that Jennifer McCabe makes is that she and Karen Read sat together in the back of a police car praying. Police cars have cameras in them. There's no evidence that ever happened. There's no evidence of it. No police were able to remember the two of them being in a police car together. All of these things are completely unproven, and the prosecution keeps stating them as facts.
How did they open the door? Because those aren't...
Exactly. I have so much glee in me that this guy has come onto the case. Apparently, he's handled a case with dog bites before. He's done these big... racketeering and big cases involving corporate stuff. So like in conspiracy stuff is sort of his field, but he also came across so strongly compared to Hank Brennan, who came across as worse than Lally. Actually, there's a moment in his closing where he sort of gives Lally a backhanded compliment by saying like, at least Lally did X or whatever. Anyway, so that's what happened at the hearing. It was wild. And the reason I didn't play any tape of Hank Brennan is because I cannot fucking stand listening to his voice.
Well, a good couple of prick quotes would be just fine. But maybe next time. All right. So last but not least, quick item. There's even more. What a bonus episode of the Readathon this is. Okay. Yeah.
Michael Proctor. Remember who he is?
Michael Proctor. Trooper Proctor. He was the lead investigator in the Karen Read investigation, and he has been suspended or put on leave, or he's not at a job at the Massachusetts State Police for a lot of different reasons, including all of his gross, disgusting text messages.
He has not been fired, however.
Right. Well, he's got a lot of union protections like most law enforcement officers do.
Well, there is a hearing on January 15th that will determine whether or not Michael Proctor will be fired.
Well, you can't say he didn't get his due process.
He got his due process. Finally, one other thing I wanted to mention from the news, the Boston Herald.
That's your third finally, by the way, yeah.
Boston Herald's a trash newspaper, we know it, but they do some good reporting too, in addition to the trash that they publish. They're sort of like the New York Post of Boston. They just did a records request and using publicly available data to look at state police salaries. Remember how Michael Proctor was transferred to Troop F? After this, which Troop F is basically like desk duty stuff. The highest paid person in the Massachusetts State Police last year made well over $500,000. The highest paid trooper working in Troop F at Logan Airport.
Just overtime?
And more than half of it was overtime. And we all know about overtime. The Boston police do not have a strong record of being accurate about their overtime.
I would just like if you're on patrol and like your beat is Logan Airport, you can walk inside the terminal in the middle of winter, stop at the Sabara, you know, and you're probably not working inside the security area.
Getting a smoothie.
Oh my God.
Yeah, going to Hudson News, getting a magazine. So that's it for the readathon today, Kevin.
Wow, very good. So are we expecting to do this again soon?
Yes.
Like maybe when Judge Cannoni comes up with some rulings in these cases?
Judge Cannoni has a lot of rulings. She's got the Voss ruling, the Arco ruling, the Marie Russell ruling, the cell phone expert ruling. They're just filing motion after. They're basically trying to exclude every piece of the defense's case, and she's going to rule on all those things. So, of course, also the Supreme Judicial Court also still has the Karen Reid appeal. In their hands, the one about her, dropping those two other charges. We still haven't. So there's a lot to come, I think, in the next few weeks, and we will be covering it all. So, Kevin?
Yes.
Thanks so much for joining me for this edition of the Readathon. Let's wrap it up.
Anytime.
Finally.
Yeah.
Partners in Crime Media.